it is time for one of the highlights of our event. John Bellinger. First of all, he probably doesn't need an introduction. How many of you know him? Raise your hand. All right, look at that. So this is all superfluous, but I will tell you this. He is currently the head of the great law firm Arnold and Porter's international law and public policy practice, which is really, really cool. He's basically doing the same thing he did as legal advisor at the State Department, but at a private law firm. But you all know that he had many rungs in his career, including being the legal advisor of the National Security Council. And recently we did a podcast where he told the story about being in the crisis management room at the White House when 9/11 was unfolding. So he was there, I mean, right in the thick of things. After a couple of years, they elevated him to be the legal advisor of the State Department. And Paul Williams and I did a book of discussions with former State Department legal advisors, asking them the question, did you think international law was real law? So in other words, the Lou Hankin question. Did the president agree with you that international law was real law? Did you ever have to tell the president, hey, you can't do this because it's against international law? And what were the alternatives that you posed? That book is now called the L Book. Its real title is Shaping Foreign Policy. It was a mini bestseller, especially at the State Department. And through that process, we really got to know John. Now, John is one of those elders, although he's not that old, but that's what we call people who are wise and have had all of these positions through the years. And he weighs in on important legal issues, and people listen when John speaks. So we're very fortunate to have John Bellinger here. Please give me a round of applause for our keynote speaker.
Thank you. It's always great to be back here because I got such great introductions from Michael, who's one of our most distinguished alumni of L. And I've got to say, congratulations. We were just, the last thing we were talking about at our table about is how hard it is to be dean of a law school these days. And you have done such a good job. So congratulations on that. Great to be back. As Michael said, I'm always particularly grateful to both Michael and Paul Williams because they literally gave me my first paycheck after leaving the State Department. This doesn't actually sound like a big deal, but when you have two kids in college and you're out of a job and you have no money coming in, it's nice when people say, well, hey, will you write a book and a chapter about being legal advisor? So thank you for that. Actually, what it did at the time, and this was in 2009, it gave me a chance to reflect on what I had done and what I hadn't been able to do as legal advisor. And I spent, during my 8 years, both at the National Security Council staff and then at the State Department, I spent an enormous amount of time on the Geneva Convention. So it's one of the reasons why I immediately said yes here. I will get into it a little bit in a minute, but as you know, we, in the Bush administration, after 9/11, detained a lot of people in Afghanistan and then in Iraq. And so the law applicable to that detention was something that I had to spend an enormous amount of time on. I was then the last person to actually negotiate amendments to the Geneva Convention. We added in 2005 the third additional protocol to the Geneva Conventions, which creates a new symbol, a red diamond, which we call a red crystal, for people who don't want to use either the Red Cross or the Red Crescent. So I was the negotiator for that treaty. I'm going to get into this at the end as to how difficult it is to negotiate Geneva Conventions. I was also the last person in the U.S. government to testify before the Senate in favor of any law of war treaties. When in 2008, I testified in favor of the 1954 Hague Cultural Property Convention, which limits cultural property sites that you can bomb, and then 3 protocols to the so-called CCW Convention, the Convention on Conventional Weapons. So that was the last time that any U.S. government official, this was in 2008, so that is 16 years ago, the last time a U.S. government official negotiated a law of war treaty or testified in favor of a law of war treaty. And again, I will get back to this because this gets into the challenges of, should we have new Geneva Conventions? Like any good law review, I'm going to proceed in 3 parts here. I'm going to try to get in all the parts. So for my timekeepers, put that down. I'm going to try to be quick, but I'm going to. I did look back, since I've spent so much time trying to get treaties through the Senate. I look back at the ratification history of the Geneva Convention. I want to just pull out a little teeny bit of history. The core of what I'm going to talk about is the core of this conference is, do we need new Geneva Conventions, and where do we need some changes? And then I'm going to end on some practical challenges, really from sort of the view of the legal advisor's office as to why this is difficult and why people on the outside don't realize quite how difficult it is. So starting with a little bit of history, obviously the Geneva Conventions of 1949 were negotiated. They were actually negotiated fairly quickly. There was some preparatory work, but they were negotiated from April to August 1949. There are 4 conventions. A lot of this is sort of directed to the students here. The first 3 conventions were on treatment of prisoners of war, the wounded and the sick, and the wounded and sick at sea. And these were based, as you heard from the first speaker, were based on prior Geneva Conventions of 1929 and prior Hague Conventions. But this was also a case of sort of something old, something new. There was a 4th convention that was added on protecting civilians in armed conflict. And this was added specifically in response to the mistreatment of civilians by the Germans during World War II. President Truman transmitted the treaties to the Senate in 1951. It took a couple of years to get them all put together and sent to the Senate. And then no sooner had they sent it to the Senate than the State Department said, hold on, don't approve these right away, because we were in the middle of the Korean War. And the Koreans were not following any rules at all. They were treating people extremely badly, and it got our military a little bit worried about, do we want to be signing up to a new law of war convention with an enemy, our principal enemy then at the time, who were not following any rules. After a couple of years of the Korean War, the government decided that they wanted to go ahead, asked the Senate to proceed with hearings, and hearings began in 1955. So a delay of 4 years, and at that point, 47 other countries, including the Soviet Union, had already ratified the conventions. So there were 4 things that jumped out at me in looking at the ratification history and the Senate consideration of the Geneva Conventions, which are relevant to how we think about these treaties today. One is how much the State and Defense Department witnesses at the time said these are simply refinements of prior international humanitarian law that had already been approved by the Senate and that the U.S. military was already following. So this was essentially just some refinements. Second, and really related to that, the witnesses emphasized how much this really reflected the U.S. practice at the time. The State Department witness, Robert Murphy at the time, said they reflect enlightened practices as carried out by the United States and other civilized countries, and they represent largely what the United States would do whether or not a party to the conventions. Third, and this is something that we really used to do more of, and it makes me sad that we are not as focused on it now, the State and Defense Department witnesses emphasized that by ratifying the conventions, we would be setting an example for the rest of the world and would raise standards of treatment by other countries. Again, the State Department witness said, our own conduct has served to establish higher standards, and we can only benefit by having them incorporated in a stronger body of conventional wartime law. We know that many nations have looked to us for an indication as to what they should do and have supported and acted favorably on the Geneva Conventions in the expectation that we would do the same. So essentially the sort of the city on the hill. And then finally, and this is interesting looking back, particularly after the debates that a number of us had, Sandy Hodgkins and I and others inside the Bush administration, witnesses in the committee consider, well, what would the U.S. do if other parties to the Geneva Conventions didn't follow them, but we had bound ourselves. And this is, I will tell you, a problem, Marguerite Walter, and I know this, the United States does not sign up loosely to treaties. When we sign up to them, we take them extremely seriously. Other countries sign up very loosely to treaties. And I will tell you, I've had conversations with other legal advisors as we are fighting tooth and nail over words. And I say, aren't you worried about signing up to this? They say, oh, it's not a problem now. We'll sign up now and we'll worry about that later. I mean, it's really just a different way of joining treaties. So the witnesses said that, here's the DOD General Counsel at the time in 1955. He said, should war come and our enemy not comply with the conventions once we had both ratified, what then would be our course of conduct? The answer is that to a considerable extent, the United States would probably go on acting as it had before, for the treaties are very largely a restatement of how we act in war anyway. So the Senate Foreign Relations Committee unanimously recommended the conventions to the Senate, stating in the report that, quote, our nation has everything to gain and nothing to lose by joining the conventions. And the committee report said at the end, if the end result is only to obtain for Americans caught in the maelstrom of war treatment that is 10% less vicious than what they would receive without these conventions, or if only a few score lives are preserved because of the efforts at Geneva, then the patience and laborious work of all who contributed to that goal will not have been in vain. And the Senate unanimously approved the conventions 77-0 in 1955. I will have to tell you, I'll come back to this then, that is not what we get out of the Senate these days, sadly. So on to the heart of where we are now. So the Geneva Conventions were almost immediately outdated. They were outdated in 1949 because they were, like most law of war treaties, they were looking backwards to sort of close the barn door after the horse had left. We were really fighting the problems of World War II. And the wars that came up in the 1960s and 1970s were different kinds of wars. These were colonial wars, and these were wars not involving large standing national armies. So fairly quickly, two protocols, which you've heard mentioned, were negotiated in the 60s and 70s called Additional Protocol 1 and Additional Protocol 2. The United States has somewhat oddly joined neither one of them. 177 countries are party to Protocol 1 and 169 countries are party to Protocol 2. The Reagan administration said that Protocol 1 was fundamentally and irreconcilably flawed, and they wouldn't even send it to the Senate. And you heard some of the concerns that were raised. I don't think we will ever become party to AP1. But this is interesting and something, I know we have a question pending in the audience on this. What happened with Additional Protocol 2? So President Reagan in 1987 sent this Additional Protocol 2, which covers non-international armed conflicts and expands on the Geneva Conventions, and urged the Senate in 1987 to rapidly approve it in 1987. Nothing happened. And it's been a little unclear, despite the urging by subsequent presidents that the Senate act on Additional Protocol 1, why the Senate has not acted. I actually called, before giving this talk, the current chief counsel of the Senate Foreign Relations Committee and said, why aren't you doing anything on AP1? And he said, well, because we haven't been asked strongly enough by the executive branch. Now, if you look at the transmittal message also on Additional Protocol 2, this is really interesting for what happened later during the Bush administration. President Reagan said, the United States is consulting with its allies to develop appropriate methods for incorporating the positive provisions in Additional Protocol 1 into rules that govern our military operations and as customary international law. In other words, the Reagan administration said, we didn't like Additional Protocol 1, but we are going to try to develop some soft law with our allies to fill in these gaps. Nothing ever happened with that. And candidly, if those rules had been developed in the 1990s, we might not have had some of the problems that we had with the lack of clarity in the law in the 2000s. So, are the Geneva Conventions fit for purpose? Do they need to be updated? My answer to the first question is resoundingly yes, they are fit for their purpose. The core of the Geneva Conventions of 1949 are still very important. There's a vital framework and numerous specific provisions that protect both combatants and civilians. Common Article 3, we call it Common Article 3 because it is common to each of the 4 conventions and sets a floor of minimum standards of treatment, is particularly important. At the same time, though, many of the provisions in the Geneva Conventions, all 4 of them, are indisputably outdated. In fact, they don't really even make any sense right now. You couldn't apply them in a modern conflict where there are no standing armies, and so they just don't really make a lot of sense. If one were trying to amend them, one could probably cut out a number of the provisions and sort of start over, but that's not possible and it's not worth doing. It's really not possible to negotiate a whole new Geneva Convention. To get 196 countries to agree on anything is impossible. This is a message for the students. You can't get 196 countries to agree on the color of the sky, literally. But that doesn't mean that we shouldn't try to augment the conventions in different ways, and there are different ways to try to augment them. So I'm going to just do briefly a dive into one of the 4 topics because it's the one that I spent the most time on. The topics of cyber, of space, and autonomous weapons, to me, seem, but I am not an expert in these areas because they have actually been coming up more since I left office, seem to be less likely topics for amendment of the Geneva Conventions and more sort of arms control treaties that might be more appropriate protocols for the Convention on Conventional Weapons. But the one topic, the panel that we just had on treatment of non-state actors in non-international armed conflicts, that, I think, really is a suitable topic for a protocol to the Geneva Conventions. Now, I'm not going to rush into that because it's difficult to negotiate anything. But I think this is actually a topic, and you heard about it, about how the law remains unclear. When I was legal advisor, and you heard Sandy Hodgkins and I, who have spent literally hundreds and hundreds of hours, mostly with the ICRC, debating this, we had a lot of discussion about what law applies to members of Al-Qaeda or to the Taliban who were captured. Were they treated as prisoners of war? Were they treated as civilians? What law applied? And the ICRC at the time steadfastly insisted there are no gaps in international humanitarian law. All you, the United States, have to do, just follow the law. It's completely clear. If you follow the rules, it will all be fine. And Sandy and I and others said, well, thank you for that. But here are all of these questions that we as a detaining power are trying to answer. And we've looked at the Geneva Conventions. Even if we applied even if we applied Geneva Convention 3 or Geneva Convention 4, they still don't have some of these answers. As you heard, often the answer we would get back from the ICRC is, well, if the answer is not in the Geneva Conventions, then you can apply human rights law. And, you should apply this or you should apply that. Interestingly, I think that the principal concern of the ICRC at the time was that if they admitted that there were gaps in the Geneva Convention, it was basically leaving room for the Bush administration to say, see, there's not law that applies. When the Bush administration left office, one of the very first things the president of the ICRC, who became a very good friend of mine, I actually got to know him so well that I recommended that President Bush meet with him personally, and President Bush did meet with him personally, and they had a nice relationship. But after the end of the Bush administration, President Kellenberger gave a big speech in which he said, there are indisputably gaps in the Geneva Conventions that need to be filled. And the ICRC got right to work on trying to fill in some of these gaps in detention in non-international armed conflicts. So In 2010, a colleague of mine in the legal advisor's office then tried to write this all up in a long law review article in the American Society of International Law called Challenges for Detention Operations Involving Non-State Actors. And we basically said that at minimum, there are 4 questions that a detaining power needs to have answers to if you're applying law, to which the Geneva Conventions do not give an answer. And the first is, who can actually be detained as a combatant? Traditionally in wars, your large standing armies, people wore uniforms. You could tell who was the other side and who was a combatant. But when we were fighting Al-Qaeda, these are people who come from numerous countries and gone into Afghanistan. And then when they were captured, they would promptly say, well, we weren't a combatant. We actually had come to do charitable good works here in Afghanistan or to look for spouses. So the question is, who is a combatant that can be detained? The ICRC started in 2009 and did a long study on this called the Direct Participation in Hostilities Study to try to determine who actually qualifies as a combatant. That became a very controversial study with some states agreeing with it. The U.S. expert who had participated in it then took his signature off of it because he disagreed with the recommendations that the ICRC came out with. A second question is, what process is required to determine whether a person actually is a combatant? For the students and all the rest of the lawyers in the room, we lawyers spend a lot of time on process. So if you're detaining someone who insists that they're not a combatant and oughtn't to be detained, what process should they have? And so we in the Bush administration at the time were said, well, you should give people lawyers. Well, there's nothing in international humanitarian law that says that a person who's being detained gets to have a lawyer to dispute whether they are rightfully detained. There is something called an Article 5 tribunal, which in cases there are doubt whether someone is a prisoner of war. But the Geneva Conventions do not give answers to what process that you should be given to essentially contest whether you are a combatant or not. A third question, which you heard alluded to, is when is the conflict actually over when you are fighting a group who come from lots of different countries and they're never going to run up the surrender flag? So you really never know when the conflict is going to be over. And more important, you don't know when it's going to be over with respect to that particular person. So a group may be continuing to fight you, but a person who you picked up who may have been fighting at the time may very well decide that, well, they really would just prefer to go back to doing something else. So how do you determine when the conflict is over so that the people can be released? There's nothing, again, in the Geneva Conventions that answers this. And again, significantly, when you are fighting a non-state actor that doesn't come from a particular country, the question is, when you do release people, where do you release them to? Do you release them to the country where you found them? In our case, often Afghanistan. Or do you send them back to the countries that they were nationals of? But in those cases, and to this day, one of the reasons why we have a difficult time closing Guantanamo is that the countries do not want to have their nationals back. So, but again, that's sort of a policy question. What's the law require? Again, it's not clear where one repatriates someone, or actually repatriation implies you're sending them back to their own country, but where do they get sent? So these are questions that the Geneva Convention still do not answer. My colleague Vijay Padmanabhan and I ourselves actually pulled from human rights law, because there are some good principles in human rights law to fill in these gaps as suggestions to fill them, but not to say this is the law that definitely applies, but to say here are some good principles that international humanitarian law could draw from. Now, as I said, the ICRC started its own process in 2012 and got a number of experts from different countries together to try to develop the law and fill these gaps for detention in non-international armed conflicts, and did a lot of good work. But states could ultimately not agree. I am told that it was largely the Russians that were objecting, but there may have been other countries. So despite a lot of good work on the part of the ICRC, no new standards, rules could be developed at least by the ICRC. So that leaves us to this day in terms of international law, meaning binding law, not much better off than we were 24 years ago. Now, we've got a lot of good practice, most of it developed by the United States, but also by other countries that the United States simply follows. And this, if you were listening, this echoes what you heard the U.S. witnesses saying back in 1955, that the Geneva Conventions were based simply on what the U.S. was already doing at the time. So our military has a lot of good practice right now, but you can't point and say, well, this is required by the Geneva Conventions or is required by this protocol. So there continues to be a lot of haziness and gaps that can be filled. So to the panel that just finished, I agree. I think this is actually perhaps the most fertile ground for development of the law, perhaps even as a protocol. Again, though, you've got to get countries to agree. I'm going to end this with some very practical considerations, though, about developing any new part of the Geneva Conventions. It's just really difficult. As I said, one, to get 196 countries to agree on anything at all. So what's better is to start in small groups. Get a small group of like-minded countries, or if you can get like-minded and non-like-minded countries to agree on something, get a small group together. This immediately causes problems with people who are not in the in-group. But it's, as you can imagine, it is a lot easier to get, say, 20 countries to agree on something and then to expand that than to start and say, okay, we're all going to get together in Geneva and with 196 countries. Again, as you heard it alluded to, we've seen this happen in the international humanitarian law area in at least two areas. One, the Danes began a process called the Copenhagen process in 2012 that included 24 governments and a number of international organizations that was specifically on handling of detainees in international military operations. And they came up with a list of 16 non-binding principles and good practices. And so that was not law, but it was 24 governments and a group of international organizations agreeing on at least what good practices ought to be. Similarly, in 2008, a group of, how many were there at the time? I guess it was about 15, 16, 20 countries got together to develop the Montreux Declaration, which was practices for private security contractors, companies that, like the one that used to be called Blackwater, that negotiate almost like, or that operate almost like private armies. I was the U.S. negotiator for that declaration. I signed it on behalf of the United States. It's non-binding, but now we have something like 55 countries who have signed up to it to say, we think these are good practices for how big private security armies ought to operate. So the point here, and this is my first point, is rather than start at 196, start with a couple of dozen. You don't start with something that is binding. You start with something that may be just good practices and say, these are practices that we think we are prepared to subscribe to. This can then morph into soft law or ultimately even into hard law. But this is really the better way to try to develop international law in this area. Second, although the ICRC does terrific work in this area, it faces a lot of difficulties in trying to develop new treaties. The treaties are signed by states. They are the ones who are bound by it. The ICRC can do a lot of the work, but this work really has to be state-led. What we have seen is that when the ICRC goes and tries to develop the law, often you will find that states will disagree with what the ICRC has said. Now, again, that doesn't mean the ICRC doesn't, and I've spent lots of time with the people at the table in the back. They're doing extremely good work. But because the ICRC comes up and says, here's a group of principles that we think that states should follow, one, that's not law. Those are good practices. And two, you will find that states often disagree. So these processes really work best if they are state-led. But then you have to find a state that will lead them. That gets me third to the United States. So we've had a difficulty until last week in that we have not had a legal advisor for the State Department for 5.5 years. We have not had a legal advisor for the State Department for any but 2 of the last 11.5 years. This is because the Senate has, in the case of the Biden administration, refused to approve a legal advisor for the State Department, and then in previous administrations, they had not been nominated. So it's been very difficult for the U.S. to exercise leadership in negotiating treaties and getting through the Senate without a Senate-confirmed legal advisor. We had a wonderful acting legal advisor, Rich Visek, who did a terrific job, but without really having been confirmed by the Senate and have the full backing of administration, it's really hard to lead. So half the people in this room know, maybe even less than half. The great news as of last week is that Margaret Taylor, a 10-year veteran of the legal advisor's office, only the second woman ever to be legal advisor, was finally confirmed by the Senate. And earlier this week, only Tuesday, was her first day on the job. She is terrific. I think she used to work with me in the legal advisor's office. Marguerite knows her well. Elle is so happy to have her, and she is going to be fantastic. And so we just have to hope that she will get 4 more years at least and not 4 more months. But I really feel this is so important. I mean, all of you know, for anything to get done, you have to have somebody to lead the efforts, to lead a new effort at a new Geneva Convention. We have to have a legal advisor. The Defense Department is very important. I'll get to this in a minute. But the Defense Department is generally looking at new international humanitarian law in a defensive way. Are we going to be able to comply with that? Is that going to interfere with our military operations? So you will not generally see the General Counsel of the Defense Department going out and negotiating a new agreement. It's usually the State Department will go out and negotiate and brings the Defense Department along the way. Finally, as you've heard alluded to, it's very difficult to get treaties through the Senate at all. So, when we're talking about Geneva Conventions or protocols to the Geneva Conventions, these are treaties that we have to get through the Senate. The Senate has simply not been approving treaties for about the last 15 years. It is unclear, as you heard me say, the last international humanitarian law treaty approved by the Senate was in 2008. It is not at all clear that the Senate would ever approve another law of war treaty. The Republicans in the Senate are now so down on basically any international law, any multilateral law, any treaties. Remember, you have to get to 67 votes. Here are a couple of statistics that some of my colleagues know. In the last 2 years of the Bush administration, when I was legal advisor, we got 90 treaties through the Senate in 2 years. That was actually more new international law on the books in that period than at any point in history. That was a lot of new international law. And this for an administration that was often criticized for supposedly not being in favor of international law. In the Obama administration, in 8 years, and I guess I will say through the 8 years of the Bush administration, 163 treaties approved by the Senate, 90 in the last 2 years. In the Obama administration, only 20 treaties approved by the Senate. In the Trump administration, only 12 treaties approved by the Senate. In the 3.5 years of the Biden administration, only 7 treaties approved by the Senate. 163 to 7 treaties. So for the academics in the room, there's much talk about the death of treaties. Are we really going to be able to do treaties anymore? So it's a huge challenge. What it means is if we want to have new international humanitarian law, and we can't get it done in the form of a treaty, it's very difficult. So, you have to start again with these standards, best practices, and see if you can build from there. And then finally, my point about the Defense Department, and I will say here is if we do negotiate any new agreements in this area, it is critical to bring Senate staff along with this. The last thing you want to do is to negotiate a treaty and then present it to the Senate, or it'll just be dead on arrival. If you can try to bring Senate staff along with you, which is not something that the executive branch normally does because we feel, well, this is our job in the executive branch to be negotiating treaties. It's your job in the Senate to be approving them after we've negotiated them. But what we have found is that if you don't bring the Senate along in the course of the negotiations, then you're going to not ultimately get it through the Senate. And then finally, the same applies with the Defense Department. Critical to have the State Department and the Defense Department completely aligned as one negotiates any new law of war treaty. One of the reasons I gave you a couple of the quotes from the ratification history of the Geneva Conventions is that much of the testimony was from, in 1955, the General Counsel of the Defense Department, who was assuring the Senate that this will not interfere with our military operations, that this treaty reflects what we do already. So, that is what we will need ultimately if we are going to have new conventions. We will need to have the strong State Department legal advisor, the Defense Department right there with them, and the Senate hopefully along as well. So I'll close by just wishing, I guess, as the representatives of the Geneva Conventions, I wish happy 75th anniversary to the Geneva Conventions. They have stood the test of time. They do need to be updated, not amended, but they do need to be updated. And that will require U.S. leadership. So I hope that is something that we will see in the years ahead. Thank you.
Thank you. So I could just listen to John Bellinger speak all day. I'm sorry that we're short of time. Do you want to take a question? It'll cut into our free time, but if you have a great question, we can do that.
I don't need to, unless you. Do you want me to ask the question, or sure?
Yeah, go for it.
Sure.
Okay. So just about non-international armed conflicts and detention, and we have additional protocol 2, which, as you mentioned, the Reagan administration put it before the Senate. The Obama administration did as well. Nothing is going to happen in the Senate. Articles 4 through 6 deal with very specific treatment rules for detainees in NIACs, as well as fair trial guarantees. It doesn't solve all the 4 questions that you were talking about, but would this be a good moment for the U.S. government, perhaps under the leadership of the new State Department legal advisor in the Biden administration, to make a statement that perhaps Articles 4 through 6 are customary international law?
The answer to that is, I think so, yes. I mean, this really is the sort of thing that a new confirmed legal advisor can do. Career staff tend to be cautious in terms of moving things forward, but when you have when you have a confirmed legal advisor, you really can break China and push things forward. So I hope that Margaret Taylor might do that. Laura, you should write a op-ed at maybe jointly at Lawfare and Opinio Juris entitled, ratify AP2 or recognize the parts that are customary international law. This is certainly something. These are steps actually that the U.S. can do without the Senate. Although there's a risk of annoying the Senate, is that the executive branch can, on its own, make an announcement that says, we like these provisions in additional protocols 1 and 2, and we are prepared to treat them as customary international law, meaning binding on states. So that is something that the executive branch could do by itself. And so I think that would be something that's worthy. There is a risk here that, if you get the wrong senator who says, well, that's something you should have taken to the Senate before you made an announcement like that. And hell, if I'm going to approve the next treaty that you send up here, but it does require executive branch leadership. So I hope you'll pursue that. It's perplexing to me why AP2 has nothing has happened.
Okay, again, thank you, John.
Thank you, Michael. Great to be here.
So, if you want to hear more wisdom from John Bellinger, he and Harold Koh, the legal advisor of the Obama administration State Department, were on a radio broadcast on Talking Foreign Policy, which is also a podcast, together with Melena Stereo and Paul Williams. The topic was foreign policy and the 2024 presidential election. Not to be missed. So now that you've heard him in person, you're going to want to click on and listen to that. All right, now cue the music from the Terminator. In 15 minutes, we'll return and we'll be talking about autonomous weapon systems. All right, we'll see you then.